Thank you so much for the invitation to be here today. I've really been looking forward to it. Haven't been to Madrid for like 20 years, so this is, Florian said it was like home to him. I think I'm just starting to getting to know the city a little bit. My presentation today concerns a paper that I wrote together with Professor Möslein, and it's named Mapping Shareholder Duties for Corporate Sustainability. And I think it must be faith that we had to put Matthias in between Florian and I, because I'm actually going to develop on some of the ideas that Matthias had as well. What we see here is that the research we have done previously on this topic clearly shows a trend towards imposing more duties on shareholders, in particular on institutional investors. And by imposing duties on shareholders, it's actually a way of empowering shareholders. So this is one of the means where you can start to pick up on some of the ideas where Matthias seems presented. The trend on shareholder duties have gained even more momentum after the financial crisis, and it extends to both company law and capital market law. And it clearly marks a break with the former perception in company law that shareholders have no duties after the share capital have been paid up. But in addition to this regulatory development, we currently also observe a second trend, which was explained by Professor Möslein earlier. And we see it again in company law as well as in capital market law, namely that legislative initiatives aim at ensuring corporate sustainability and long-termism, and it includes the shareholders' duties as well. And these two regulatory developments do not only occur simultaneously, they also seem to interact. And it is this interaction between the two trends that we try to explore in our paper. I'll get back to the shareholder duties trends just shortly. Oh, sorry. But let me just start where Professor Möslein concluded by taking a look at the drive for corporate sustainability. And the Commission has not only dealt with this topic in the action plan, which was presented earlier, but also some of the earlier initiatives, such as the amended Shareholder Rights Directive from 2017 and the Directive on Non-Financial Reporting from 2014, deal with some sustainability issues that we pick up on in our paper. While the European Sustainability Agenda, especially within the action plan, has a clear focus on the investment situation, it also, like Professor Möslein explained, has some clear corporate governance implications. And in this respect, the agenda follows two different paths. One path concerns the corporate social responsibility and directors' duties in that respect. And the other one concerns the investors and the to-be shareholders. And because of this focus on the shareholders, which we also find in the amended Shareholder Rights Directive, the two legal initiatives, the action plan and the amended Shareholder Rights Directive, are the two that are of most interest to us in our work. And if we take a closer look at these two initiatives, they seem to follow a similar approach. First of all, they aim at incentivizing investors and shareholders in general. And this is based on the idea that investors acknowledge the business case by which sustainable performance correlates with better financial performance, but also that engagement by the shareholders correlates with a better financial performance. Both such business cases have been much debated, but are clearly applied by the Commission in their work. And second, the initiatives impose duties on specific shareholders that are either in a special position, or subject to special regulation. And in this respect, both initiatives are much more demanding than just incentivizing, since they aim at actually imposing proper duties on these groups of shareholders. So before I move on, I'd like to take a closer link between the duties of the investors and the duties of the shareholders. And what we see in the action plan, as well as in the amended Shareholder Rights Directive, is that the directives and the action plan have a focus not only on the investor, which is sort of the pre-investment situation, but also on the shareholder and the duties of the shareholder in the post-investment situation. And while it's true that investors do not become shareholders until after they have actually invested in a company, we see that also the initiatives that have a focus on the investor have a clear impact on the coming role of the shareholder. And that's what's interesting, and that's what we try to explore here. And part of this link can be explained by the fact that when investors have made their investment and become shareholders, they play a very important role in the companies in relation to monitoring and assessing the long-term value of the companies and in the management of the sustainability risks. Other market actors may also engage in this assessment, but the shareholders have a unique position in companies and in corporate governance. And company law across member states grants shareholders a number of fundamental rights that are exclusive to this group. And therefore, they make up a very important internal corporate governance mechanism that doesn't affect any of the other interest groups of the companies. And the Commission has increasingly emphasized this role in their work on shareholders and shareholder rights, as well as shareholder duties. So even though the action plan mainly focused on the investors, we also see that it actually includes initiatives that concerns the shareholders. And this is what's called Action 7, where it says that it will clarify institutional investors and asset managers' duties, especially in relation to what they call fiduciary duties. And I'll get back to that in a second. But also the amended Shareholder Rights Directive have a provision that sort of link the investment with the shareholder situation, as the shareholders have to include information on how their investment strategy and how their engagement strategy sort of interact. So we clearly find a connection in both the legal initiatives. And what we do in our paper is that we take our starting point in some of our previous work, as mentioned by Alfonso. And what we tried to do here was take an overall view of the shareholder duties that we find in company law and capital market law today and map them. And what we find here is that there is great variety as well as great variance in the different kinds of duties. And it's going to take too much time to go through them all, but in order to give an overview, I'm just going to focus on a few and try sort of to categorize both the variance and the variety. And if we start by looking at the variety of shareholder duties, we find that they mainly have variety in two aspects. That's in relation to the sources of shareholder duties and in relation to the interests they aim to protect. And if we look at the sources of shareholder duties, we find that they derive from a range of different sources. At one end, there are contractual duties, which derive from contractual arrangements between the different company constituents. And at the other end, we have the statutory duties. And in between, we have duties that derive from legal principle or has been developed by case law. And the variety of the source of the duties is not really surprising, because the different duties have developed in different contexts. And it's probably not surprising either that when we look at shareholder duties, we mainly find them in statutory law. Because unless duties are mandatory, we would expect shareholders to opt out of the duties, unless a majority of the shareholders, of course, accept the duties. And while contractual elements might be found in company law, this is clearly not the case when we look at capital market law, which is the other area that we explore. And in general, capital market law is much more characterized by having a top-down approach and a more proactive approach in order to protect market integrity and efficiency, so it's dominated by statutory law. If we turn to the group or the interests that are to be protected, it actually correlates with what Matthias Siems just said, because what we find is that the duties mainly tend to maintain the interest of three groups. The first concerns the company, other shareholders and stakeholders. The other is the interest of the market as an institution. And the third group concerns the duties that protect societal interest in general. And if we look at the duties imposed of shareholders in respect of the investee company and other company constituents, they can mainly be explained by a contractual private law perspective, because they're mainly imposed in situations where shareholders can be understood as agents, not principals as we usually think of, but as agents. And this is in relation to other constituents such as consumers, creditors, and employees, and most importantly, in relation to other shareholders, where we have the majority-minority perspective. Most of these duties can be seen as governance duties, but a few can also be characterized as financial duties. And what's really interesting here is the governance duties, and most of these are aimed at ensuring transparency, which is an important element of the internal corporate governance instrument. And they're usually imposed on specific shareholders or groups of shareholders who have the potential to exercise significant negative influence on the company. sorry. In the second group, we find duties that are imposed on shareholders in situations where shareholders are in a position to cause market failure. And many of these duties also relate to transparency and do to some extent overlap the duties we found in the first group. But here the aim is to protect the interest of a market as an institution. And finally, in the third group, we find duties that are imposed on shareholders, aiming at protecting wider societal interests. And this is actually interesting because we usually don't find that kind of interest in company law or in capital market law. And even though they are few and limited, they may be on the rise, so to speak, as I will get back to in just a second. And now I'll turn to the variants of shareholder duties. And what we find here is that they mainly vary along three different axes. First, the different types of investee companies, where we find what's really important here is whether it's a listed or a non-listed company. And of course, that's not surprising when we look at capital market law, but we also find it in respect of company law, in particular in relation to the Shareholder Rights Directive. The second situation that's interesting is the different types of shareholders, because usually the different characteristic of shareholders doesn't matter, except when it comes to institutional investors and states that has ownership. In that respect, we find certain duties that vary with the type of ownership. And finally, when we look at the different types of business situations, we find that duties are mainly imposed in situations where there's a fundamental structural change to the company and not in relation to the ordinary life of a company. So now I'll turn to the variety of shareholder sustainability duties and concentrate on that type of duties. Again, it's not surprising that what we find is that these types of duties are mainly imposed in statutory law. And mainly they are imposed outside of company law and capital market law. And that might not be surprising because they mainly relate to the investment situation. And what we find here is that it's mainly in sectoral specific instruments such as the usage directive, the Solvency II directive, the IORP directive, and so on. So it relates to different types of shareholders and their investment situations. And except for the IORP directive, there's actually no mentioning of specific sustainability duties, but what they do mention is that they mention the prudent man rule. And the prudent man rule has some resemblance to the fiduciary duty that we find in common law. And what the duty expects is for the institutional investors to act in the best interest of the investor or the beneficiaries. And this is kind of interesting in respect of the interlink between shareholder duties and sustainability duties, because it's not clear whether it only relates to the investment situation or it actually also has some impact on the following governance situation. A different source is found in the amended Shareholder Rights Directive, where we find a hardened version of soft law in Article 3G and 3H, where we have a disclosure duty on the institutional investors. And it leaves it to the institutional investors to determine how the investor will comply with the substance of the provision. And thereby it has some resemblance to the corporate governance code that's found around the European member states. And if we look at the interest to be protected, I'm just going to mention one which differs this type of duties from the other types of duties, and that's what we call other interests. And other interests are actually the interest of the beneficiaries of the institutional investors. And this is interest because the interest of the beneficiaries of the shareholders is usually not something we deal with in company law or in capital market law, but now with the amended Shareholder Rights Directive, we find this aspect to be very prominent. And the sustainability duties that aim to protect the beneficiary's interest are mainly made up by the fiduciary duty or the prudent man rule. And like I mentioned before, this is interesting, but it's also problematic because we really don't know what is included in this duty. And in particular, in relation to the fiduciary duty found in common law, it has even been discussed whether institutional investors are allowed to include sustainability considerations in their investment decisions and in their management decisions. And when we look at the different directions that mention the prudent man rule, it doesn't make us any wiser at all, because it doesn't have any reference to what's actually the substance of the duty. We just know that the investors are expected to take care of the best interest of the shareholders. And when we look at the variance of the institutional investors or the sustainability duties, we find more or less that these are the same as we find in general. So what really makes a difference here is that when we look at sustainability, we start to include the whole investment chain, from the companies to the intermediaries to the end investor, and that's what makes a difference here. And before I make my concluding remarks, I just want to comment very briefly on enforcement, something that was also mentioned by Professor Møslein. Because when we look at the emergent sustainability duties found, especially in the Shareholder Rights Directive, it's somewhat different from what we usually find in relation to enforcement. Because the member states are responsible for ensuring that the institutional investors live up to the comply or explain principles. So there is some kind of formal enforcement on the disclosure duty. But the enforcement of the actual content of the duty is not with the member states. And it's very unclear who's actually expected to enforce the duties, to enforce that the institutional investors engage in a meaningful way and then they disclose in a meaningful way. And when we look at the directive and the preamble, we don't really find the answer there. And the problem is that the duties seems to be aimed at taking care of a lot of different interests, but the different interest groups, the beneficiaries, the markets, the shareholders, they don't really have the right means to actually enforce these duties. And this is one of our final conclusions, because what's actually making this process even more complicated is that by adding a different perspective into the regulation, we find that the regulation of this type of duties on shareholders become much more complex, because the duties that are imposed on the directors of the companies and the duties that are imposed on the institutional investors that relates to the market and the beneficiaries are somewhat interlinked. And whether the duties here can be expected to have an impact on the actual transformation into a more sustainable economy and a more sustainable financing depends very much on how we can enforce these duties. And when we look at the action plan, most of the initiatives in the action plan hasn't been transformed into actual initiatives yet. So we have to wait and see whether the Commission decides to go down the same path, mainly relying on principles that are unclear and where it's unclear who's actually going to enforce them, or whether the Commission is going to take a different path and impose more specific statutory duties on the investors and the other participants in the investment chain. Thank you very much.